The first case to come before us is State of Ohio versus James Mapes. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve time, please let me know as I will be keeping track of the time. The arguments are being recorded. Please keep your voice up and remain behind the podium. You should not use the name of children, minors, and victims during your argument. You can refer to them by initials or terms like the child. The judges have read your briefs and are ready to proceed when you are.
Good morning. May it please the court. Representing Judge Lanzinger, Judge Sutton, Judge Stevenson. My name is David Sheldon, and I represent James T. Mapes. I would respectfully request 3 minutes of rebuttal. Your Honors, this is a pretty simple case. I wrote a brief, and it touched on every significant issue regarding this appeal. This is an ALS appeal arising out of Wadsworth Municipal Court. The underlying OBI charge was eventually dismissed in the case. The trial court specifically reserved jurisdiction on the ALS appeal. To hear the ALS appeal, the court heard the ALS appeal. Obviously, my argument was on the face of the 2255 form. There was insufficient information for that officer to have reasonable grounds to arrest my client for OBI. And as I mentioned, and you have the form, I wanted to make sure you had the form because the judge mentioned taking judicial notice. And I know from my past experience with the Court of Appeals, if the exhibit is not made part of the record, you presume regularity in proceedings, and there's nothing really to consider. So I had her specifically mark it as Exhibit A and introduced it into evidence, so you had that before you to look at the form. But as I mentioned, it's pretty simple. The only ground I challenged in the ALS appeal was whether or not there was reasonable grounds under 4511-197C1 for the officer to arrest my client for operating vehicle under the influence of alcohol. In my brief, I cited the Mahoney County case, State versus Harding. In that particular case, which I think is, I cited because I thought it was so analogous to this case, even though it's from the 7th Appellate District. I thought it was so analogous to this case. And I can't remember what the ALS form in that case had, but it was very scarce in terms of evidence that would suggest any type of impaired driving, any traffic violation, any other indicia of intoxication, balance and coordination. Any of those things were missing from the form. And of course, I analogized to my case, for this case, glassy eyes, odor, and STs without an officer's explanation, simply insufficient grounds to arrest somebody for operating vehicle under the influence of alcohol. It doesn't indicate any, and I know Mr. Roberts argued to the trial judge in this case, well, normally, that means this, that means that. We can't infer from these words what they mean. You need an officer there to testify.
But isn't the burden on the defense, on the defendant, for an ALS appeal?
Yes, it is, Your Honor.
So wouldn't that be the defendant's burden to present evidence that there wasn't reasonable?
Well, in Your Honor, I presented the evidence, and that was the form. And if you look at the Mahoney case, it's like, hey, the burden doesn't even shift to Mr. Sheldon if the form itself is facially deficient in terms of an explanation of the grounds for arrest, and that's why I argue here. It's simply, the burden doesn't shift to me, even though I introduced the form. I took the lead and said, okay, Judge, here's the form, here's what we're talking about.
Did you actually have a hearing then?
Well, there was no testimony presented, so there was no...
Was it actually set for a hearing, because the time for an ALS appeal hearing is within days of arrest? Right.
So you have 30 days from the initial arraignment on the charge to file your ALS appeal, which was done in this case. So it was timely filed, and we had the hearing. It wasn't my obligation to bring in a police officer to explain what these words mean. That's not my obligation. That's the state of Ohio's obligation under the case law I cited. We don't even get to Mr. Sheldon having to put on any evidence if the form itself is facially deficient to support reasonable grounds to arrest. And that's my entire argument in this case. We don't even get the burden shifting to me to put on evidence, even though I submitted the form in this case. So that form was part of the record. Query whether or not I didn't submit the form, and you rejected the notion of, hey, judicial notice is sufficient enough, we need the form, I don't think we'd be here, period. But I submitted the form, and my argument was a legal argument, totally legal argument. So, and I mentioned in the brief, and I think it's on page 7, where I say that the Harding case, if the form is insufficient on its face to establish reasonable grounds to arrest, the state has the prima facie burden, which would not even shift if the BMV is inadequate, no testimony from the arresting officer is presented. That's exactly what we have here. And in that case, the court summarized, quote, most importantly, the form mentioned nothing about an observed traffic violation or infraction involving erratic or improper driving, impaired physical coordination, overly deliberate movements, speech issues, unusual or suspicious behavior statements, nervousness, problems retrieving documents, confusion, or some similar indicia of intoxication. That's at paragraph 15 of the decision, close quote. So that's clearly analogous to this situation, Your Honors. We don't have any of that. We don't have the arresting officer's testimony. So based on the face of this form, it's insufficient as a matter of law to establish reasonable grounds to arrest for OVI. On the alternative issue I brought before your attention, the second assignment error was because she dismissed, if you disagree with me on the first argument, assignment error number 1, on assignment error number 2 should have been, well, if she's dismissing the OVI, it's terminated pursuant to law, therefore the ALS should be terminated pursuant to law.
But isn't the ALS a separate matter? If there's reasonable belief that you are impaired on a public highway and you don't submit to a test, or you submit to the test and do the per se limit, isn't that an administrative suspension that is separate than anything that happens in the criminal case or criminal traffic case?
Well, it's an interesting issue. Some courts make it a civil proceeding, Medina Municipal Court makes it a civil proceeding. You have to file a petition for privileges and a civil ALS appeal. In a civil case, file a civil filing fee. In this case, it's filed in the criminal case along with the OVI charge. So
well, the
it's not
reason
a
you're here,
separate...
though, is because it's its own separate final appealable order in an administrative capacity, right?
Correct. This is, from the case law, it's a separate appealable issue, which is why I brought it to the attention of the trial court. But I'm saying if the court disagreed with me on assignment error number 1, if she terminates it, and my argument is she didn't because she retained jurisdiction. I think she properly invoked the jurisdiction of the court to retain it over the ALS appeal, so I really don't think we get to issue number 2, assignment error number 2, but if we did disagree with me on number 1, I think then the argument is, well, then you should have terminated the ALS appeal if you dismissed the OVI. But based on all the facts and based on the arguments I set forth in my brief, I think they're spot on in this case. I would ask the 9th District Court of Appeals respectfully to reverse the trial court's decision and grant the ALS appeal. Thank you.
Thank you. May it please the court, presiding Judge Flagg Lanzinger, Judge Sutton, Judge Stevenson, opposing counsel. I'm Jared Roberts. I'm here on behalf of the state of Ohio. I think Judge Flagg Lanzinger got the first issue correct, is that because the ALS appeal hearing is more akin to a civil hearing, it is on the movement, the burden is on the movement by preponderance of the evidence to show that one of the factors in 4511-197 was not met. In this case, at the ALS appeal hearing, which was held on June 18th, 2024, he simply introduced the BMV 2255 and rested. There was no other evidence, no testimony, and the state's position is, and I think the law is, that a properly sworn BMV 2255 is prima facie proof of the truth of the statements contained therein. In this case, the officer did fill out the form. It is properly executed. It's witnessed, notarized, and sworn. So admitting the prima facie proof of the thing is not meeting your burden by a preponderance of the evidence that it's insufficient on its face. It was incumbent upon the movement in that hearing to produce something, some testimonial evidence for the court besides the form, and they didn't do that. So the state's argument regarding that is they simply didn't meet their burden.
But if the form is clearly deficient on its face, why would they have to produce evidence?
Well, I think
I mean, what at that point, they've met their burden. If the form just said, I pulled this guy over because I felt like it. I mean, that's not what it said, but at some level, if the form just said, I pulled over because I felt like it, what you have to have come forward with some evidence is explain why that took place. And I'm not saying that's the case, but if that's their argument, we can review that argument and say, you're right, it's deficient on its face or not. If we agree, then so be it, and if we don't, we don't.
I think in the scenario you're suggesting, Judge, is if there's information missing, if he hadn't put anything, glassy eyes, odor, SFSTs, if that was blank, maybe there's an issue where that's deficient on its face. If it's not notarized properly, it's maybe the form is sufficient. But in this case, the form is properly executed and completely full. And in fact, the officer noted in 2 areas that he was an OBI investigation. The chemical tests were refused. As the court's aware, and what I argued to the trial court, is this form it's separate from the police narrative. It's limited in its scope. It's an administrative form that goes to the BMV. And the officer, it's commonly associated with OBI. And so when an officer notes glassy eyes, well, anybody who practices criminal law knows it's okay, bloodshot glassy eyes is an indicator of impairment. Odor could have been, elaborated on, and the SFTs, again, they're in the common language. We wouldn't write those, the officer wouldn't write those down if the person did well on them. So I think the court can infer the use of the form. And also, I think what the court did was notice that there's limited space on this. It's not meant to be an all-inclusive statement of the case. That's why it's filed along with the officers. The officer presents a narrative as well. Regarding the second issue, I think it's pretty clear that because this was an administrative license suspension based in part on the refusal to submit the chemical test, and I cited in my brief State v. Hare, 4511-197, a dismissal of the charge does not equal the termination of the ALS. It survives because there has to be some consequence to the refusal itself. That's why it is separate from the criminal component. Part, driving is a privilege, not a right. So there has to be some consequence if you refuse.
Well, there doesn't have to be, but there is, and that consequence is the suspension that exists. The legislature has said, here's a penalty if you don't do that.
That's correct.
The legislature could have said, there's no penalty for cases submitted, but they chose not to.
They chose not to, correct. But that I don't believe the state has anything further, unless there's other questions from the court.
Thank you. You'll have a full 5 minutes if you'd like it.
I don't think I'll take 5 minutes, Your Honors. Just in response to Mr. Roberts' argument, again, it's not Mr. Miggs' burden once it's established that the form's insufficient on its face, and I think Judge Stevenson hit the nail on the head. It wasn't sufficient on its face. Those words are simply not enough. We need some explanation of what they mean. Odor. Okay, he's saying infer odor of alcoholic beverage. Let's assume that's true. Was it mild? Was it moderate? Was it strong? Glassy eyes. I have glassy eyes right now because I got about 4 hours of sleep last night. What does glassy eyes mean to the officer? Standardized field sobriety test. Okay, how do you do on the standardized field sobriety test? How many clues did he score on the HGN? How many clues did he score on the walk and turn? How many clues did he score on the one-night stand? We don't have any testimony to support anything that would explain any indicia of impaired driving. There's no mention of driving, impaired driving. There's no mention of slurred speech. There's no mention of any other indicia, potential indicia of intoxication.
Counsel, you say there's no other indication, but wasn't the form, didn't it state at the bottom, I certify I arrested the person having had reasonable grounds to believe the person was operating a vehicle on a public highway, a highway or upon public or private property used by the public for vehicular travel under the influence of alcohol and or drug of abuse? Didn't the officer certify that on the?
He did certify that, Your Honor, but that's an issue of fact for a court to determine. I mean, the officer would certify anything he wants. I mean, get to a trial by jury, it's beyond a reasonable doubt. In this case, reasonable grounds to arrest. So he's saying, I have reasonable grounds. Well, what are those reasonable grounds? Well, I'm saying an odor alone, glassy eyes alone, and SFSTs alone are to establish, is sufficient to establish reasonable grounds to arrest. I'm arguing, no, it's not. We need an officer here to explain what these terms mean. You can't just infer anything without anything more from the record than what he wrote on that form. So for those reasons,
I still understand if this was actually set for a hearing, because if you're arguing something on paper with a alleged facially deficient form, wouldn't the prosecutor then be able to have a hearing where the prosecutor would subpoena witnesses? There's also special rules about when you have that ALS hearing at the beginning of a case. It's supposed to happen very quickly. So was this actually set for a hearing where a prosecutor could subpoena a
yes,
witness?
it was set for a hearing.
And it was an oral hearing
It was, well, or an evidentiary
with
hearing.
no evidence other than
The form.
than the form.
Right, so meaning, my argument is, Your Honor, and I believe there was evidence in the record, you'll have to look at it, but I know there's evidence in the record. Mr. Roberts started making a motion, well, if I need the officer here, I'm gonna file a motion to continue, and ultimately acquiesced in going forward with the hearing, so.
And was this after the OBI charge was dismissed, or was it early on in the case?
I believe she already dismissed the OBI and then retained jurisdiction to have it.
And then the
ALS
defense,
appeal.
and then the defense requested that hearing?
I requested the hearing from the get-go, meaning I filed my request
So
for
it
an
was
ALS
just, it was
appeal.
just pending during the,
It was pending, I believe it was already continued one time, I believe, to this particular day when we had the hearing, so. And I even said, I think in the record, well, I brought in the officer the first time, I can't remember, I apologize, you'll have to go with the record, but I apologize why it was continued in the second hearing. But I didn't bring the officer in the second time, because I'm saying, I don't need to bring in the officer.
well, the burden is on you, there's no doubt on that, right?
Yeah, yes, Your Honor, but again, if you use the 7th District's analysis and rationale, which I asked you to adopt in this case, I struggle to find cases, and I apologize, you may have a case right on point that I didn't find out of the 9th District, but the burden doesn't even shift to my client to put on any evidence if the form's insufficient on its face, so. Thank you, Your Honors, and I respectfully request the court reverse the decision of the trial court. Thank you.
This court will take this matter under advisement and issue a decision in due course. The clerk of courts will mail you a copy of the decision on the day it's released. The opinions are also published on the Supreme Court website. Thank you both for your presentations.